And we're back with our final segment on Talking Law TV with Christie Register. Hi, Christie.
Hey, Michael.
Good to see you again.
Thank you.
And we're here today to talk about bankruptcy and how it can possibly help some people.
Yeah, I think in this economy, a lot of people are wondering that question.
Well, what happens if you make the decision? Well, first, let me back up. What helps you decide this person needs to file for bankruptcy versus crack down on their bills and just pay everybody?
The short answer is see a lawyer, and they will look at the pros and cons of filing or not filing, or which chapter to put you under. So you really just need to meet with an experienced bankruptcy attorney.
So what happens when you decide that is what you're going to do? Then you decide between Chapter 7 and Chapter 13.
For individuals, correct. And immediately upon filing your petition, whether it's under Chapter 13 or Chapter 11, Chapter 7, the automatic stay comes into play. So you're protected from your creditors. Your creditors are stayed from taking further action against you without approval from the court.
And what is that? How do you put that into place?
Your petition is filed with the court.
How do they find out about it?
The court sends notices to your creditors. In the bankruptcy petition, of course, is the debtor's name, address, and identification information, and all of the creditors that the debtor owes. So when the petition is filed, the court sends out notice to those creditors.
Now, is there a penalty against them if they continue to call after they've been notified?
There is. You can basically take them into court with an adversary proceeding, and the judge will hear the evidence and hopefully punish them if they willfully violated the Bankruptcy Act. Now, out of fairness, when you file your petition, I'd like to tell my clients it may take a week or two for the notices to get sent out and for the creditors to get it in their system. But certainly, if somebody's filed bankruptcy and they're contacted by a creditor, they just need to tell them, I filed bankruptcy, this is my lawyer's phone number, and it should stop.
Then you just hang up the phone.
Yeah.
Can you still be sued by someone else?
In general, no. Any debts that you owed on the date of that bankruptcy filing are considered to be under the bankruptcy. So in order to be sued, then this creditor would have to get permission from the court to do that. First things that come to mind would be domestic support. Bankruptcy in general does not stop actions involving child support and alimony.
Okay. Now, if you're still getting these calls we talked about, and you've told the court about it, and they don't stop, and they've been brought in, or some are just relentless. They just won't let go. What can you do?
My experience has been, once a creditor is informed of the bankruptcy filing and you give them a case number, they stop.
Are there exceptions to people who will be allowed to call?
No.
Everyone has to stop.
All creditors listed in that petition have to stop. And another reason is, too, this debtor is now represented by counsel. So if somebody's represented by counsel, you don't contact them directly, you go through the counsel.
Okay.
So we deal with it.
What are the other benefits of filing for bankruptcy?
There are several benefits that apply to different people. If you're being garnished, that will stop. If if you're about to lose your house, it'll put that arrearage into the bankruptcy plan. If your car's about to get repossessed, if you file Chapter 13, which is reorganization, those behind payments go into the plan. One big benefit is for people who owe back taxes, and you file Chapter 13, which is reorganization, where you make the payments for 36 to 60 months, the fees and penalties stop.
And what about Chapter 7 with back taxes?
In general, monies owed to a governmental entity are not dischargeable, so it's not affected. So anytime I have somebody that owes more taxes than you can pay, say, in the next 6 months, my advice is usually go Chapter 13. Okay. Otherwise, you're just kind of spinning your wheels. You may be making payments on the taxes, but the fees and penalties occur really quickly, and you don't really get anywhere.
What if you have a car or a truck with a really high interest rate? Is this a good time to just let it go?
If there's a code section that says if you bought your car more than 2.5 years ago, then you can value that vehicle, meaning that you just pay the value of it. You look it up. We use NADA, Kelley Blue Book, and see what the fair market value is. If you bought it within the last 2.5 years, you can bring the interest rate, but you have to pay the full amount of debt on the car. So, you know, I'm seeing a lot of people who bought a vehicle at 20% interest. Bankruptcy can help, and the interest that you pay, the rate is close to prime.
So they're technically what they call upside down in the car.
Right.
They could have a $15,000 truck that with $25,000 bills.
Right, right. If you can value it and it was bought outside that 2.5-year window, then it may be something that you want to keep. If not, and you got to pay for it fully secured, maybe something you want to surrender, that debt will be discharged because it's pretty much money out the window.
Now, who do you pay the lower amount to? The same people that have the loan, or do you have to go apply for a new loan?
No, it would go through the trustee. In Chapter 13, the debtor makes their payments every month to the trustee, and then the trustee disperses money to the secured creditors, or to the creditors.
And so he just lets them know, guess what, you've got a new amount.
Right. Part of Chapter 13 is a plan, which is provided to all the creditors and gives them notice of what you are proposing to pay. Of course, creditors are free to object, but once that plan is confirmed, then that's pretty much your blueprint for your bankruptcy case.
How much time does it usually take a Chapter 13 to go from filing to everyone being paid off? Is there a time limit?
Yes, 60 months is the time limit. In general, cases need to go for at least 36 months unless they're going to be paid in full at 100%. So 36 to 60 months.
We've seen a lot of big-time entrepreneurs, home builders, file bankruptcy. Some of these people owe millions of dollars. Are they in the same category in 60 months to pay millions of dollars?
No, no. I think what you're referring to would be Chapter 11, where businesses, corporations file and kind of their debts are put on a shelf for a number of months. There are debt limits with filing Chapter 13, and it's a little over $1 million. So Chapter 13 is for individuals, whereas Chapter 11 is for businesses.
And what about a sole proprietor? Where does he fall?
Usually under Chapter 7 or Chapter 13. I'm meeting with more and more people whose businesses are failing or whose businesses have failed. And often, if you have a small business that is no longer in operation, for all intents and purposes, the business is dead, so the business doesn't really need to file bankruptcy. The individuals who guaranteed those loans for the businesses may be the option that they need to take, either with 13 or 7, just depending on the situation.
Now, if you're a small business owner and your spouse has another job, when you file bankruptcy, do you do it just by yourself, or do you have to drag her down with you?
That's what your bankruptcy lawyer can help you decide. If your spouse has a lot of debt, or say, for example, if to get your business going, you got loans or credit cards and your spouse is on those loans and credit cards, then your spouse may want to file with you. You always have the option, though, of filing individually.
Okay. So if you're newly married and you find out your intended didn't tell you the whole truth and nothing but the truth?
Right. Then, in that case, maybe the spouse with the debt would file, because obviously if it's premarital debt and the other spouse didn't know about it, then his name wouldn't be on it. So,
does that affect your credit record?
No.
Just even if you share the same domicile and everything?
Nope, does not affect it.
Okay. And I know the fees are built in for Chapter 13 by the courts, right?
Right. There's a standard no-look fee of $2,500. The filing fees are around $300 for 7 and 13. Chapter 7 cases, the fees vary depending on how complicated the case is.
And some can be very, very complicated.
Right.
And others are fairly simple.
Some people come in, they've got 2 or 3 creditors.
Okay. Well, thank you so much, Christie. If you have any questions about bankruptcy and like some help with it, you can look up Christie through our website at talkinglawtv.com or call her through our toll-free number at 888-203-7-LAW. Thank you for watching Talking Law TV, and we hope to see you again here next week. Bye-bye.